From Arkansas, Mr. Griffin.
Thank you, Mr. Chairman. I want to follow up with some questions for you, Mr. Sanchez. I was reading in your written statement when you were talking about, and these pages are not numbered, so you have a section here where you're talking about the transparency that normally surrounds the acquisition of documents via grand jury subpoena.
Yes.
And you indicate that it is impossible to overstate the significance of the transparency that normally surrounds the acquisition of documents by those means being via subpoena, grand jury subpoena. Could you talk a little bit about what that transparency is?
Right. Well, so insofar as normally on the criminal side, those processes do not involve gag orders as 215 orders and national security letters normally do. The incentives, I believe, are different for companies served with those orders. They're not always incentivized to stand up for the privacy rights of their customers, the people whose records they are in custody of. But we see frequently booksellers or companies like Google moving to quash subpoenas, specifically citing the ground that they fear that their reputation would be damaged by the disclosure of the fact that they were turning over sensitive records without making any kind of move to limit the scope of those subpoenas. By contrast, what we've seen, and again in at least the national security letter and 215 cases, is that often when there have been identified misuses, they've typically occurred with the enthusiastic collaboration of the record custodians. Often violations of the rules occur because of overproduction.
I'm limited on time here, so I guess in my experience, I haven't seen a lot of transparency with regard, and not that it's warranted. I mean, the whole nature of a grand jury process is secrecy, and I'm not sure where you're going with that, where you're going with your transparency argument, but the grand jury issues the subpoena in secrecy. It's issued and complied with in secrecy. The documents are obtained and brought to the grand jury. So I'm not exactly sure what that argument is that you're making there. But I also want to go over here. You talk about the Patriot Act's roving wiretap provision includes no parallel requirement that an individual target be named. We just discussed that. We were given the example of at least identifying the individual, even if you don't know the name. But then you go on and you say that you say, quote, "This is disturbingly close to the sort of general warrant the founders were so concerned to prohibit when they crafted our Bill of Rights." A little hyperbole there, maybe. Mr. Litt, would you comment on that? Do you? And this gets me to the broader question, and this is what I've heard a lot back home. If you would each just, I know I'm running out of time, just briefly comment on the constitutionality of the three provisions that we just voted to extend. Do any of you have constitutionality concerns? And if this was asked previously, I apologize. Why don't we just start on the end and go down?
No, Congressman.
Mr. Litt?
No, I don't. I think the only two issues that have been raised with respect to the lone wolf provision, I think there's been concern expressed that this may be beyond the national security powers as set out in the Keith case. And I think that when you have a situation where you're talking about non-U.S. persons who are engaged in international terrorism and a collection which is certified to be for the purpose of collecting foreign intelligence, I don't think that's a serious constitutional concern. And similarly, for the reasons we've previously discussed, I think that the roving wiretap adequately meets the particularity requirement of the Fourth Amendment.
Mr. Sells?
Thank you, Congressman. I agree with that as well. I think we're pretty far away from the days of King George III. FISA, as amended by the Patriot Act, doesn't allow the sort of general warrant dragnets that we justifiably, our founders justifiably worried about 200 years ago. That's not the situation that FISA authorizes. In all cases, FISA, as amended by the Patriot Act, requires probable cause to believe that the target is an agent of a foreign power, i.e. somebody who's a spy or a terrorist. That seems like it meets the particularity requirement pretty precisely to me.
Looks like
Time of the gentleman has
time.
expired.
Thank you, Mr. Chairman.